And hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of all others. As always, I hope you enjoy this legal education content. And today's the day I earned that subscription. For today's story, we are talking about a copyright fight that was going on with respect to the car, Eleanor, that appeared in the 2000 movie, Gone with 60 Seconds. There has been a copyright fight that has been going on, depending on how one counts such things, for 14 years or longer, depending on how we count such things. We'll get a little bit into the story, and we're also going to read a decision from the district court, the Central District of California, dealing with this. So first of all, let me give you a little bit of background, and I'm sure the court will go into some of this as well. So you might be familiar with the 1967 Eleanor Mustang as featured in the movie, the 1967 Shelby GT 500, and Gone with 50 Seconds as maybe a starring role in the movie with Nicolas Cage in 2000. But 2000 was not the first time that there was a movie called Gone in 60 Seconds. So this story actually starts in the original Gone in 60 Seconds, which came out in 1974. So in 1974, there was a movie released called Gone in 60 Seconds. It was directed by Henry Selick. While working on his own 1989 remake, he died in a stunt gone wrong. So the original director of the original film filmed the original movie Gone in 60 Seconds in 1974, and he died in 1989 during a remake. Toby had married a woman named Denise 3 months before he died. So being his wife, she acquired certain assets of his by nature of law, one of which was the right that retained in the estate to the rights of the movie Gone in 60 Seconds. Because he was the director, he owned the rights. And so she now has the rights to the movie. So in 1995, she closes a deal with Hollywood to do the big budget reboot, which came out in 2000, which of course featured the 1967 Shelby GT 500. In 2002, Carroll Shelby attempted to trademark the car in the movie. So the woman who was married to the director, Selick, sued Shelby in 2004. And after 4 years of legal roundabouts, which is why, where does the story start and where does it stop? How far back are you going in time, right? So in 2004, there was this initial lawsuit. In 2008, there was a settlement that Shelby granted Selick exclusive rights over the Eleanor Mustang. But over the next preceding 14 years, her lawyers have tried to go even farther by saying that Selick owned the copyright to any vehicle named Eleanor, all the vehicles named Eleanor. So she says, okay, I am the widow of the original director of the original movie. One of the things that I acquired as being the widow is these rights to the movie. I gave the rights to the movie to film the remake. The remake featured the car. Therefore, I own the car. I own the car. And all cars named Eleanor. I am the owner of all things Eleanor. All right? So that went on. And in fact, perhaps somewhat notably, it impacted a YouTuber as well. There's a YouTuber named B is for Build. B is for Build was part of this drag of copyright infringement lawsuits. And in 2020, B is for Build had to pull 14 videos in a series devoted to building what he called an Eleanor Mustang. So he took a modern car, a modern Mustang, and he was trying to transform it into a 1967 Eleanor, at least give the appearance there too. So he had to give up his videos and also the car as part of the settlement. So there are lots of aftermarket companies that want to sell kits called Eleanor to transform various cars into the 1967 to make it replicas. But this woman who was the widow of the director was suing basically everyone on site, including fellow YouTubers, to prevent them from doing that, saying that she owned a copyright to the car because the car in the movie is a character, was her argument. So she owns the copyright to the character, the car, right? So this goes to this concept like the difference between the idea and the expression. So one way I like to express this dichotomy, the idea expression dichotomy, is by pointing out quite correctly that anyone can write a book about a bunch of prepubescent children who go off to a wizarding school and have a bunch of adventures. But only J.K. Rowling can write Harry Potter. And only J.K. Rowling can write the character Harry Potter or Hermione Granger or Ron Weasley, right? Those are her characters. Those are her expressions. So anyone can make anyone can make a book about a bunch of children going off to a wizarding school. Only J.K. Rowling can make Harry Potter. And only J.K. Rowling has rights to the character Harry Potter. So this was her argument. Her argument is that the car is in and of itself a character, in the same way that Harry Potter is a character. And therefore they own the copyright to it. Now, to my mind, this doesn't make any sense, because there is also a difference in copyright versus patent. Copyright can't protect useful things. Copyright does not protect things that have utility. Copyright extends to non-useful things. Harry Potter is a very interesting work, but it is not useful. It can't do anything. It's a book. It's a story. It just sits there and you read it and you enjoy it. It can't do anything. It can't transform matter. It's not a chemical. It's not a machine, right? It is non-useful. Copyright only extends to the non-useful, right? The other characters in the movie are non-useful. They only exist as people on a page. They can't do anything. This is where the argument kind of breaks down for me. Because Eleanor, the car, is a car. It's useful. It does things. It can drive places and can take cargo and take people and all right, all the rest of it, right? So you can't get copyright in a useful thing. So this is why this argument never made sense to me, or doesn't make sense to me. Because the car has utility. If this argument made sense, it would allow you to get copyright in anything featured in any movie that had utility, which would completely undermine the separation between copyright law and patent law, right? If you want protection in something useful, talk to the patent office. That's what they do. Unfortunately, the patent for the 1967 Eleanor Mustang expired long ago. Long ago. Hence why anyone can make the useful article, because the patent expired long ago. Now, the trademark rights, maybe, but the actual useful article, right? But she's trying to claim copyright. It doesn't really work. All right. So with all that background and explainer, for me to give you the brief history of this and explain some of the legal issues that are in play, we now turn ourselves to the court decision, which we are going to review in detail and discuss. So this is Carroll Shelby Licensing versus Denise Halicki. Carroll Shelby is the widow of Shelby. Denise Halicki is the widow of Halicki. The two widows fighting each other for, all the rest of it. All right, so let's do that. Actually, Carroll Shelby is the guy. I misspoke there. Oh, well. Actually, whatever. It doesn't matter. Okay, pressing on. Carroll Shelby's dead now. Someone else. All right, so Carroll Shelby and Carroll Shelby Trust separately moved for summary judgment on a central issue of this case. Well, whether Eleanor, the designation used to refer to a series of automobiles across 4 feature films, incidentally, in the original Gone in 60 Seconds, it was also called Eleanor, and it was a different car, completely different Mustang, but a different car. So whether Eleanor, the designation used to refer to a series of automobile against 4 films, is a character subject to copyright. The Shelby parties and the Halicki parties filed motions for summary judgment concerning these issues. The court heard motion based on discussion and oral arguments and arguments in the papers concerning ownership of intellectual property. The court ordered the joinder of Hollywood Pictures and denied a motion without prejudice to renew. So one of the things is a joinder of parties, right? One party sued another, but sometimes other parties should be part of this lawsuit, right? So sometimes parties who are not in the lawsuit can force themselves into the lawsuit. And sometimes parties that are not named in the lawsuit can be forced into the lawsuit by the court because they are a necessary party. They're a necessary party. One of the things that helps you determine if they're a necessary party, the short definition is, would a decision involving this substantially prejudice the other party's rights in a way that they wouldn't be able to fix? Right? So basically, does this court case affect a judgment against a third party? Which sometimes happen, right? So this dispute would resolve between these two people. But maybe not just these two people. Maybe this would resolve the issue as to other people, including, various people in Hollywood who might have an interest in this. So one of the things the court can do is one of the things you can do is you say, okay, there is a necessary party to this because a decision in this would prejudice their rights in a way that a future lawsuit from them would not be able to fix. That's one of the short ways that you can do that. So it's like, okay, let's bring Hollywood Pictures into this thing. So here is what we got between all these parties. The case concerns 1974 film Gone in 60 Seconds, the 1982 film The Junkman, the 1983 film Deadline Auto Theft, and the 2000 remake of Gone in 60 Seconds. All four feature films feature Ford Mustang cars given the designation of Eleanor. The Haliki parties own copyrights to the first three films, and the court assumes for the purposes of this order that they own any intellectual property rights and interest in Eleanor as it appears in the remake. Over a decade ago, the Haliki parties and related entities initiated litigation against Shelby and related entities, claiming that Shelby parties were licensing improperly obtained trademarks relating to Eleanor for manufacture of imitation vehicles labeled a GT500E. So maybe the problem is that you're calling it Eleanor. Maybe the problem is not that you're making the car. Maybe the problem is you're calling it Eleanor. We own the trademark Eleanor. You own the trademark Shelby. Maybe that's the issue. Okay. So after years of litigation, including a trip to the circuit court and back, so I told you this litigation's been going on in various forms for some time, depending on how we're measuring such things. So how are we measuring such things? But yeah, 14 years, 18 years, take your pick. But something like that. The parties entered into a settlement purporting to resolve the dispute. The detente did not last. Under license from Shelby, the CR parties made a series of cars with the designation JT500CR that the Haliki parties claim infringes their rights in the Eleanor character. So they're making a new GT500 variant, and Haliki says, ooh, shiny, mine. The Haliki parties demand that the CR parties cease and desist, and also began contacting GT500E owners and auction houses to assert intellectual property interests in those vehicles and prevent resale, which doesn't really make any sense, incidentally, because of the first sale doctrine. But, okay, right? Copyright in a particular thing extinguishes with the thing, in a particular embodiment of the thing. So if you buy a copy of Harry Potter, you can resell that copy of Harry Potter, right? This is the first sale doctrine. Copyright in that particular manifestation, particular embodiment, particular copy of the thing extinguishes with the first sale. But they're going nuts over here, contacting auction houses and like everyone else in sight, saying you can't resell the car, which again doesn't make any sense, but gives you a sense of their aggressiveness in their copyright fight. They are looking for it all, including things more than they're perhaps entitled to. Okay. The Shelby parties initiated this suit, claiming, among other things, the Haliki parties conduct breach of settlement. So one of the things is like, okay, you are doing things that are outside our agreement, so no. Haliki parties maintain counterclaims against Shelby for copyright infringement and breach. So they both say that they have breached the contract. They both claim breach. Okay. Summary judgment is appropriate when there's no genuine issue of material fact and the moving party is entitled to a judgment as a matter of law. A fact is material when under governing law, the resolution of the fact might affect the outcome of a case. So not all facts are material because not all facts would change the legal analysis. If there is a material fact in dispute, then we need to go to some sort of fact-finding stage. Usually that's a jury, but not always, of course. But if there's no material fact in dispute, then, there's nothing for a jury to do. It's just pure law. So, okay, is there a dispute as to any material fact? A dispute is genuine if the evidence is such a reasonable jury could return a verdict for the non-moving party. The burden of establishing absence of genuine issue and material fact lies with the moving party. So the person asking to not go to the jury has to prove there's nothing for the jury to do, which makes sense. And the court must view and draw reasonable inferences in the light most favorable to the party not asking for it, which also makes sense, right? We don't want to go to a jury because there's nothing for a jury to do. Okay, prove it. It's your obligation. To meet this burden, the moving party may introduce evidence negating an essential element of the non-moving party's case, or after suitable discovery, the moving party may show the non-moving party does not have enough evidence of an essential element or defense. So there is some sort of quantifiable threshold here. It's like, again, is there enough for a jury to do? Is it possible for a jury to rule in your favor? So there can be sometimes some suggestion, but that's not enough. There has to be some real chance at all, right? Again, if it's a slam dunk, let's all go home, then fine. Once the moving party satisfies its burden, the non-moving party cannot simply rest on pleadings, arguing that any disagreement or metaphysical doubt about a material issue precludes summary judgment. Again, you may disagree about something, but whether or not that's a thing that matters is what matters. So you may disagree about many things, but not all those things are relevant to the issue. There's no genuine issue for a trial when the record taken as a whole could not lead a rational trial or fact to find for the non-moving party. Again, this is either because there is no evidence or what little evidence might exist is so thin. And so whatever, that's like, no. So that's basically the standard, but you have to prove that, right? And we're going to interpret anything, all doubt against that. Okay. The Haliki party submit request for judicial notice of certain documents. Okay. The Shelby parties object to judicial notice of some of the documents based on relevance. So we want to take notice of certain documents, for example, probably the settlement agreement, otherwise known as the contract, right? Take judicial notice. This is a fact now, which, fair. The leaky parties do not explain why the documents are judicially noticeable and what adjudicate facts they seek to extract. So if you want to take judicial notice, you have to show the court why we're doing that, and no. Leaky parties appear to rely on some of the documents, including judicial opinions and legal briefs in support of legal rhetoric. The court has considered these documents for legal argumentative purposes, advisory committee notes, but does not need to take judicial notice of adjudicate facts in these documents to resolve the motions. So judicial notice is for facts, right? That's what it's for, not for law, right? Because like the law, the court is always under judicial notice of the law. That's what they do, right? The court, of course, is under judicial notice of the law. That's the nature of law. What you're here for is judicial notice of facts. I want the court to just say something is true, right? I don't want to go to a jury. I don't want a trial. I don't want a finding. I don't want a hearing. I just want you to declare a certain thing to be true. You can do this if it is beyond all dispute within the jurisdiction of the court. So if it's within judicial notice of the geographic district of the court. Also, of course, if it is, a legal determination, not that you need the finding, full faith and credit, but, if you did, if there was but that's a legal determination by a different court. You're not. So I guess you could say that's a factual determination, a court concluded thing, but whatever. Right. So basically, is this a fact that's beyond all dispute? And the court is saying, well, you want me to take notice of judicial decisions. So fine, but I don't need to determine the facts within those decisions, right? The judicial decisions that exist for principles of law. I don't need to know whether or not the facts within them are true because the law is the law. I'm not going to re-adjudicate those cases. That would be dumb. And also, none of the facts that were relevant to those cases are relevant here. How some other contract might have said with respect to facts is not my issue. My issue is the facts of this case. So I've read your judicial determinations. I take notice of the case law for its value, but I'm not taking judicial notice of the facts within them because who cares? Fine. The parties submit voluminous objections. The court need not resolve many of these objections to adjudicate the motions. To the extent that the court relies on objected evidence, the objections are overruled. So again, some of these evidentiary objections are non-relevant because I don't care, right? It doesn't matter either way. The evidence comes in, the evidence doesn't come in, it doesn't matter either way. It doesn't resolve any of the issues either way. It's like having a dispute over something completely tangential that no one cares about. It's like, why are we fighting over this? It just doesn't matter to the issue. So I don't have to resolve the rules of evidence because, well, I could say they're admissible, but I just ignore them anyway, so whatever. And to the extent that you have a problem with it otherwise, then go away. Okay. So, to the issue at hand, the parties dispute whether Eleanor is a character subject to copyright protection. I'm going to go with no, personally. It's a car. It's a car. The car is not a character. To the extent the car has character, its character is a feature of its function. Its character is derived from its function, right? To the extent that a car can be said to have character, it's because of the way the engine is built and designed. It's because of the way the suspension is built and designed. It's because of the way the wheels work and the tires work and the transmission and the differential and the body shape and the handling and the 0 to 60 time and its space and interior and its engine noise and whatever. But every one of those things is derivative of function, right? All those things are derivative of a function. They're all based on function. You can't do that. You can't do this. Okay. Harley Davidson, somewhat famously, tried to get a trademark for its engine sound. This is going way back. This happened a long time ago. But Harley Davidson said, we want a trademark for our sound of our engine. Our engine has a distinctive sound. And the courts are kind of like, well, that might be true, but the sound is derivative of the design of the engine. The reason it has that sound is because the way the engine is designed. The engine is protected by patent or not. Once the patent expires, anyone can make that engine. That's the nature of patent. Once the patent expires, anyone can make the thing, right? So whatever is necessarily derivative of the thing can't be given additional protection, because if it did, it would completely undermine the point of patent law. It is a necessary function of the thing. It has to be that way. It has to be that way because of the function of the thing. So no, you can't have a trademark in the sound, because if you did, it would mean that no one can produce that engine, and it can't mean that. So you can't have the trademark in the sound. So no, Harley Davidson, you can't have your trademark. By the same extension, whatever might be said about the character of this car, for good or ill, is a feature of its build. It is a feature of the components of the car that went into it. And if you make that same car again, it will have the same character, necessarily, because it's derivative. And if you change those parts, it will have different characters. But even those changes would be derivative of its function. So you can't have your trademark and you can't have your copyright that is derivative necessarily of the function of the thing, because now you're intruding on patent law and you can't do that. So yeah, I think this is just a total non-starter legally for me. Annabelle gets $49.99 to say, have a wonderful new year. Thank you very much, Annabelle. I appreciate that, and very much. And Merry Christmas and Happy New Year to everyone who's here. I appreciate it. Just remember to do all those YouTube things, like, comment, subscribe. As always, I appreciate it. Thank you very much. And thank you to the new members. I've seen a couple of you pop up as well. So for me, this is a pretty easy issue. on copyright law. It's like you can't have a copyright in the thing because in this instance, you can't have a copyright in the character. You can't have a copyright in the character because its character is necessarily derivative of its function, and you can't do that. So, yeah. So the parties have skirmished over this issue, but no court has definitely resolved it. For me, it's fairly simple. In one of the leading cases in the circuit on character copyrightability, an appellate panel examining Eleanor character suggests that Eleanor might be protectable, but only recommended on this fact-intensive issue to the district court. I don't think it is. I don't think it's copyrightable. And if it was, I don't know about any of that because it's copyright and it's necessarily derivative of its function. That seems. The parties settled this matter before the issue could be conclusively resolved. Unfortunately, this does not stop another Ninth Circuit panel from viewing Haliki films, recharacterizing the facts, and advance a discussion of copyrightability with the implied yet strong suggestion that Eleanor is subject to protection. I'm not really sure about that one. Thank you very much, Miss Emma, for saying you like the thumbnails. I appreciate that. I really thank you very much. Thank you. Much of the Ninth Circuit's panel commentary on copyright issues appears to have stemmed from unfortunate practice on part of the Haliki parties to embellish the facts. Due to space limitations or inadvertence, several of these exaggerations were left unchallenged and made their way onto court orders when this matter was put before judicial officers. From there, factual inaccuracies made their way into a published Ninth Circuit opinion that likely assumed the facts were true, unfortunately not so much. So the district court is calling you out, big time. They're saying you lied to the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals seems to have suggested facts that no, you somewhat exaggerated. And so, no. You did it bad. They say maybe it's because of inadvertence. For example, the Ninth Circuit in Haliki film stated that the original and remake of Gone in 60 Second films, thefts of other cars go largely as planned. But whenever the main human characters try to steal Eleanor, circumstances invariably become complicated. Even assuming that's true, that truth is not derivative of the car. That's derivative of a plot artifice of the writers. There's nothing about the car that makes it inherently harder to steal. And even if it did, that would be derivative of its function too. So basically, you can't win on this. This conclusion is patently false. In the original film, several vehicle heists take left turns, as one thief is surprised by a live tiger in the backseat of a vehicular marked, and others debate what to do after discovering bricks of heroin in another vehicle. In the remake, one thief is surprised to discover a snake in the vehicle with a license plate snake. The apparent owners of one vehicle interrupt the heist by getting intimate in view of the vehicle. And keys for 3 vehicles must be retrieved from the bowels of a canine by feeding it laxatives. The ladies are dirty. While the court recognizes the importance of zealous advocacy, parties always need to be mindful of their obligations to be candid. So maybe you were being less than truthful. Also, even if it was true, I'm not sure it changes the legal analysis one way or another. Even if every other car boost had gone perfectly to plan, except for this one, that's just a way to make the film interesting. If all the car boosts go perfectly, it's probably not as interesting a film as some of them going wrong. Also, it's not based on the nature of the car that it goes wrong. Also, even if it was, it wouldn't matter. Accordingly, in connection with copyright motions, the court dispenses with the parties' argumentative characterizations of the facts. Instead, the court has independently scrutinized the 4 films. So the parties have argued some shit, and the court had movie day. I wonder if they had popcorn and shit. Got the whole staff together and had, let's watch movie time. I mean, it's a good day as a judge, right? You get to watch a movie and write it off as part of your work. So the court actually watched the film, which is fair enough because the thing does speak for itself. It's a film. Anyone can go watch it. Having done so, the court concludes as a matter of law that Eleanor is not subject to copyright. So yeah, yeah. The Ninth Circuit has adopted a 3-element test to decide whether a character featured in a work is copyrightable. Okay. So we want to do a test to decide whether or not a character that appears in a work is copyrightable. So how do we decide that thing? Well, it would help a lot if the character had some originality that sprung to the mind from the mind of the writer, which again, while the writer has some thoughts on the stealing of the car, that's not in the nature of the character of the car. The writer cannot increase and decrease the character of the car. He can make what happens to it more interesting, but the character's kind of fixed by the physical thing. But here's what the Ninth Circuit said. Although characters are not innumerable copyright matter, there's a long history of extending copyright to graphically depicted characters, which kind of makes sense. Although they're not listed as a copyrightable element, they exist as part of copyrightable elements. And so the courts say, well, that's copyrightable in and of itself to some degree, which, makes sense. However, not every comic book, television, or motion picture character is entitled to copyright. A character is entitled to copyright if the character has physical as well as conceptual qualities. Right away, we're off to a bad start when it comes to the car. The car has no conceptual qualities. The character is sufficiently delineated to be recognizable as the same character whenever it appears and displays consistent identifiable character traits and attributes. No. The character is especially distinctive and contains some sort of unique element of expression. No. So even assuming somehow a car could be copyrighted, which I'm not sure that's possible, but let's go with the premise that somehow cars are copyrightable, or at least we don't have to decide that issue right now. We fail for element 3 because there's nothing distinctive about the Eleanor car. It's just a 1967 Shelby GT500. It's just the car. There's nothing special about the car. It is just the car. So maybe you could get a copyright for some sort of car, maybe somehow. If the car talks or something, that would help. Then it's a character. So, what is it? Herbie the Bug? Herbie the Bug's probably copyrightable. But, not you. So, no. The parties do not dispute the first element, which is readily met. Across all four works, Ford Mustang automobiles are given the designation of Eleanor and assigned feminine pronouns. They assumed the car's gender. Lol. Accordingly, the court focuses its analysis on the second and third elements of the test. In this analysis, the court has considered the 4 forms together as closed, cohesive universe of works, which is consistent with how the Ninth Circuit panels have applied the test. So maybe the Batmobile. Maybe the Batmobile is copyrightable. Maybe. But it's pretty distinctive. So, okay. The court acknowledges some ambiguity in the Daniels test that might create doubt on the propriety of this approach or wisdom of the test. So the court is like, well, there might be some problems with that test unto itself. So the court is doubting the law a little bit there, which, fair enough. The second prong requires the court to consider whether a character is recognizable as the same character whenever it appears. This suggests, as Carroll Shelby permits, that a character cannot be afforded independent copyright protection unless there are multiple works in which the character appears, giving measuring consistency and recognizability across appearances. That would be fatuous without a collective work. Further, consistency inquiry raises the question of whether a character could become uncopyrightable, or whether copyright interest in character could mutate upon publication of work or works featuring a copyright character with traits and attributes inconsistent with prior iterations. For example, the Ninth Circuit has long approved of a district court decision finding copyrightable interest in the character of James Bond. Under the framework of Daniels, the court wonders how this interest in Bond might be affected, or whether it should be affected if the next actor to be cast in his role were a woman, among other traits you could make. So then you get into this wonderful question. You get into this wonderful question about what is the character of James Bond? What are the elements of his character or her character? And James Bond has been portrayed differently on the screen by different actors. Their expression of the work is not the same. Is it the same character every time? You know, it's just there's questions there. What is the nature? How consistent is consistent? So there's, and then, you know, because a real person has complexities to their character. A real person isn't just a constant series of common tropes. So how much can you change about a person before they stop being the same person? How much can you change about the character before they stop being the same character? We are now Ship of Theseusing. We are now Ship of Theseusing this thing into the philosophical, which is always fun. Okay. These reservations about the test, however, do not fall outside the scope of what the court has asked. The court applies the test as best it can be interpreted. All right, so we have some problems with the test because we see it has some breaking points. But we're going to try to apply it anyway for the best as we can. All right, so the court briefly summarizes observation from the film. All right, so let's go through the appearance in the works and describe Eleanor and its various manifestations. Gone in 60 Seconds, the primary characteristic of cars with the Eleanor designation is their fungibility. In the film, the protagonists, Mandrian Pace and his team, are assigned by an unnamed, apparently disreputable individual to steal 48 different automobiles of various makes and models within a limited amount of time. I mean, stealing does make it somewhat disreputable. Pace asks his associate to assign each type of vehicle to be stolen a common feminine given name as a code name, and instructs his team to only use the code names. The Eleanor designation apparently refers to a Ford Mustang, and there's a little footnote here. Although the characters in the film use the Eleanor designation to identify only one 1973 Ford Mustang Fastback with yellow and black coloring, it's unclear whether the name designation is that specific. As depicted in one shot, the name designations may simply refer only to makes and models. For example, Judy is a Ferrari of unknown model, and Nancy is an Eldorado of unstated, though implied, make. That said, Pace recounts Eleanor as the last of the Mustangs, implying that multiple Ford Mustangs were on the list of cars to be stolen. So we're not even 100% sure what Eleanor necessarily is in the first movie. We know it's at least a 1973 Ford Mustang Fastback with yellow and black coloring, but we don't know if it's only that, because of the way they treat other names in the movie. Maybe it means all Ford Mustangs. Maybe it's more generic than that. We're not quite sure. The movie didn't say. So that's an interesting little detail. The court continues. That is, the Eleanor designation primarily serves as taxonic or classificatory rather than appliative function. Accordingly, the heist team in the film refers to 4 different vehicles by the name Eleanor to denote they fit the description of the car they must steal. So apparently it relates to 4 different cars, 3 of which we don't know quite what they are. So are they all 1973 Ford Mustang Fastbacks? I don't know. We're not clear on that thing. We're not quite sure what Eleanor is in the first movie. The gang of thieves encounters the first Eleanor at an airport. After Pace and his associate identify the vehicle as Eleanor, the associate approaches the driver's side door to steal the vehicle, only to encounter a woman with glasses and curlers, apparently asleep in the driver's seat. Saving face, the associate explains, "I thought it was my car," and retreats with a heckling Pace. Having taken notice of the license plate, Pace locates the vehicle and steals it from the driveway of its own owners, the woman with glasses and curlers, and a man later identified as Harold Smith. Smith and a police vehicle pursue Pace. The police arrest Smith, who explains he was pursuing his stolen yellow Mustang. The police return Smith to his house to find the Mustang in the driveway. Pace later explains he returned the car to spite Smith, whom he dislikes for mishandling of insurance claims. The second Eleanor appears only briefly. A woman parks her Ford Mustang at a residence in Gardenia, California. Pace pulls up to the residence and uses a tool to disengage the vehicle's lock and enter it. Later, Pace's allies alert him to a classified advertisement in the newspaper indicating the vehicle is uninsured. Having sworn not to boost uninsured vehicles, Pace abandons the Mustang on a dirt road. The film spends most of the screen time with a third Eleanor. Pace and an accomplice first enter a Ford Mustang on the road after stealing the second. Pace remarks, "When you don't need them, they're all over the place. Never know, we might need another Eleanor." He takes note of the vehicle's apparent home, the International Towers in Long Beach. After abandoning the second vehicle, Pace steals the third from International Towers. Having been tipped off by a disloyal member of Pace's team, the police engage Pace in a chase sequence that lasts over 40 minutes. Over the course of the sequence, Pace's vehicle sustains significant damage to its body. In the climax of the chase, Pace's vehicle careens over an overturned vehicle and flies through the air in a minute-long slow-motion shot. Having lost its pursuers, Pace leaves the vehicle with an attendant at a car wash. Sounds exciting. Pace discovers the fourth Ford Mustang at the car wash. He convinces the owner to leave him with the vehicle under false pretenses. He drives off, replaces the license plate, and is allowed to drive off at a police checkpoint. No character refers to this fourth vehicle as Eleanor, but maybe it is Eleanor. Because, the way they treat the other Eleanors. We're not sure. Could be anything. In short, Eleanor is in Gone in 60 Seconds is a taxonomical idea the protagonists apply to vehicles with the shared set of vehicle characteristics, apparently make and model. But each instance of Eleanor featured in the film has a unique conceptual characteristic, such as ownership, provenance, and insurance status, and physical characteristics, such as distinctive license plates, and particularly in the case of vehicles stolen in a chase sequence, damage. Although Eleanor is billed as the star of the film in the opening credit sequence, it's unclear to which instance, Eleanor, if any, the credits refer. Further, although people in the film often refer to Eleanor instances by name and using feminine pronouns to discuss cars visiting the destination, no human refers to Eleanor as if it is human. Well, that was an exciting recitation of the 1974 film, Gone in 60 Seconds. So the court believes, based on its analysis, that multiple cars are referred to as Eleanor and other cars fitting the description aren't referred to as Eleanor, but they might be Eleanor. Also, even though 40 minutes of the film was devoted to a chase involving one particular Eleanor, we are still unsure which Eleanor the movie credits was referring to as the star of the film. So, it could be anything. Maybe the cameo is the star. Who's to say? Right? I like this very much. I like this. This is fun. Okay, so let's turn to Junkman, 1982. In contrast with the first film, Eleanor's name in Junkman serves as an appellate function. In a meta-turn, the Junkman is set against a backdrop of the fictionalized production of a feature film, car stunts, and premiere of Gone in 60 Seconds. So there's a movie within a movie now. Exciting. Harlan Hollis, the fictional director of Gone in 60 Seconds, the movie within the movie, is targeted for assassination before the film's premiere. A yellow and black Ford Mustang appears in 4 new sequences, 1 non-diegetic and 3 diegetic, and in clips from the first film. In single shots of the non-diegetic opening credit sequence, a toy car, a yellow and black Ford Mustang with damage mimicking that sustained to the vehicle in the chase scene from Gone in 60 Seconds, sits in a diorama and takes credit as special guest. The vehicle is unnamed. So maybe Eleanor's the toy car in the diorama. Who's to say? In 3 diegetic scenes, the physical appearance of the single vehicle depicted is similar to that of vehicles the protagonist drives and severely damages in the chase sequence in Gone in 60 Seconds. The damage to the body of the car matches damages to the car of the prior film, but the car in the Junkman is painted with messages written across its side. Eleanor from the movie Gone in 60 Seconds, and a pull quote exclaiming, "The most hair-raising chase scene ever filmed." I imagine some of you may want to challenge that particular designation, but you can do that. And why don't you give me what you think is the most hair-raising chase scene ever filmed? Which one is the most hair-raising to your mind? In the first scene, 2 people in the studio warehouse, collection of vehicles, toys, and memorabilia argue over Eleanor's present location. Referring to the vehicle by the name Eleanor, one directs the other to have the vehicle transported to a location of the premiere in Gone in 60 Seconds, the movie within the movie. Neither talks to the vehicle. In the second scene, Hollis evades a gunman on foot through a warehouse. Eventually, Hollis locates the Mustang, drives it through a wall, and uses it to climb over another wall to escape the gunman. The people in the scene do not name the car or talk to it. In the third sequence, the climactic action sequence at the premiere of Gone in 60 Seconds, a stylized painted description of a yellow Ford Mustang is featured in Gone in 60 Seconds posters, and Eleanor appears in the background of certain shots. The vehicle is depicted only fleetingly in frame. I just love how this is kind of required for the court to do this, because we're on a motion for summary judgment, right? And the trial court is the finder of facts. And what Eleanor is in these movies is part of the factual picture. And the movies do speak for themselves. So the court's in a perfect position to analyze it based on movie day. Right? The parties can argue all bunch of things, but the court can just say, well, okay, the movie speaks for itself and I can watch it. And these are findings of fact. These are facts that the court is reciting. And it kind of has to do that to some degree because the court has to find the facts in order to properly apply the law. And I find that kind of hilarious that the court is compelled to reduce these movies to this this narrative descriptor. It's a very interesting aspect of the legal system. It's fun. In Junkman, Eleanor appears as a film prop or object d'art. Ooh. As demonstrated by Eleanor's diegetic appearances in the warehouse collection location and a fictionalized premise of the premiere at the original film, its functions as a vehicle are secondary to its symbolic meaning as emblem or relic of Gone in 60 Seconds. Hilarious. So Eleanor is not really a character in the film. It's more of a prop. It's a MacGuffin, maybe. Something like that. No, it's not a MacGuffin. It's more a MacGuffin in the first and third and fourth movie. It's more of a prop. That's a better way to put it, I think. Okay, movie number 3, which we're going to spend one paragraph to. Deadline Auto Theft recycles and repurposes footage from Gone in 60 Seconds and The Junkman in service of a revised plot echoing the first film, featuring protagonist Adrian Pace. There are minimal difference between the original film and Deadline Auto Theft relevant to the analysis here. The scene at the airport to which the first Eleanor is left on the cutting room floor, some dialogue is changed and removed, and Eleanor's not billed. So dialogue, the court apparently is not a huge fan of Deadline Auto Theft. The court thinks that Deadline Auto Theft is basically just the original 1974 Gone in 60 Seconds, just again. The court thinks it's the same goddamn movie with a different title. So the court as movie critic over here is not feeling Deadline Auto Theft. It doesn't feel like it brings anything to the picture. That's kind of hilarious. That's kind of hilarious. You gotta love that shit. All right, Gone in 60 Seconds, the 2000 movie. In the remake, the codename Eleanor again serves as a taxonomic function. A retired car thief, Memphis Reigns, must steal 50 cars within a limited amount of time, else a gangster will kill his brother. Reigns assembles a team and assigns each type of vehicle to be stolen a feminine codename so that he may discuss their marks without garnering the attention of law enforcement. In the film, the Eleanor designation refers to a 1967 Ford Mustang Shelby GT500, an uncommon vehicle within the narrative. The film establishes that Reigns has never successfully stolen Eleanor, notwithstanding multiple attempts. Reigns describes Eleanor as a unicorn. Actually, strictly speaking, I don't think it was Reigns that described it as a unicorn. It was one of the other characters that described it as a unicorn. But whatever. It was it wasn't Reigns. I don't think Reigns ever described it as a unicorn. It was someone else in the movie. But okay, details. The film visually depicts two instances of cars of the Eleanor designation. The first is a vehicle painted gray and black located at International Towers in Long Beach. The vehicle is the only auto fitting the Eleanor description in the area. Reigns talks to this instance of Eleanor as if it's a human on several occasions. The detective, it's one of, but when he first meets Eleanor in the LA Towers parking garage, one of his associates, one of his fellow car thieves, refers to it as a unicorn in that scene. So it might have been the detective, but it was also one of the fellow thieves referred to as a unicorn. We're going to get through it this time, right? I know we've got a history, Eleanor. You take care of me, I take care of you. This, Eleanor, is the last of 50 vehicles to be stolen. At International Towers, Raines uses his tool to break into the car and start it. Upon his exit, he encounters law enforcement, beginning a chase that serves as the film's climax. During the chase sequence, Raines skillfully drives Eleanor through an urban area. Pursued by multiple police vehicles and a helicopter on the Los Angeles River, Raines engages the vehicle's nitrous oxide system for a burst of speed. Raines breaks the Eleanor's side mirror. The vehicle engine stops, and Raines pleads for it to restart. Raines circumvents a traffic jam by using the bed of a tow truck as a ramp and flying over the jam, resulting in further damage to Eleanor. Upon delivery, the antagonist orders the vehicle to be destroyed. During the film's denouement, that's great. During the film's denouement, the Raines brother presents Raines with the keys to the second instance of Eleanor. Raines brothers explains he lawfully purchased the vehicle. The car is rusting and stripped off paint, and its engine sputters and struggles. The Eleanor designation in the remake serves a similar purpose to the designation used in the original film. It is a taxonomic identifier used to refer to cars of a similar physical description. The designation again refers to any vehicle of a certain phenotype. The court really likes its word choices, man. Denouement, phenotype. Man, the court really likes its vocabulary. That's great. The designation refers to any vehicle of a certain phenotype, regardless of other physical and conceptual characteristics such as provenance, color, and operability. Notably, the car described by Eleanor's moniker here is different than the car described by that name in the trilogy. Having reviewed the films, the court now applies the Daniels test to the purported character that the Haliki parties seek to protect. Okay, well, that was a very insightful recitation of the vehicles involved in the car, in the thing, and Eleanor, the real Eleanor is the friends we found along the way. Let's continue. In the second prong of the character copyrightable test, the court examines whether the character is sufficiently delineated to be recognized as the same character whenever it appears and displays consistent, identifiable character traits and attributes. Although a character that has appeared in multiple productions or iterations need not be consistent, it must display consistent, identifiable characteristics and attributes such as recognizable whenever it appears. Okay. By contrast, a character that lacks a core set of consistent and identifiable character traits and attributes is not protectable because the character is not immediately recognizable as the same character whenever it appears. Which, you know, okay. So if Haliki owns copyright to the first 3 movies, and whatever Eleanor is not sufficiently similar to those Eleanors to be the same Eleanor. It's a different character by the same name. Right? Something like that. By contrast, okay, we left that one. According to the Haliki parties, Eleanor is a highly customizable Ford Fastback Mustang, continually referred to with the unique name Eleanor. Eleanor is hard to steal and is a unicorn or a collusive beauty, sensitive, temperamental, and exhibits strengths, talents, and endurance. Eleanor is able to outrun and outmaneuver police, saves her leading man, and is capable of performing death-defying jumps and hair-raising long chase scenes. Eleanor also breaks down and doesn't start, and people talk to her. No, I'm not really feeling like any of that to be, yeah, okay. As should be evident from the summary above, most of these traits and attributes are not consistently or identifiably exhibited by the characters in the works. Some are never to exhibit. The court acknowledges that character may be protectable despite some level of inconsistency. See DC Comics, concluding the second prong analysis favored protection of Batman or the Batmobile, even though the precise nature of the bat-like characteristics have changed from time to time. The Batmobile may be distinctive enough to be a character. I suppose. It is a heavily customized thing. So, maybe. Although I'm still not sure, to be quite honest. But the problem there, of course, is its intersection with patent law. Right? The problem is its intersection with patent law. I suppose you could try to split the difference and say that some of the elements are non-functional, but that's kind of hard when it comes to a car. Everything. I don't know about this. Yeah, this isn't this analysis, but even the court had doubts, incidentally. The court earlier in the same opinion that we're reading right now has sort of chided this analysis for its problems. So I share the court's skepticism that this test is really necessarily the end all be all of whatever it is we're trying to do here. But someone said the Batmobile was protected, so okay. Here, the volume and primacy of the inconsistency erode much of what the Haliki parties claim is fundamental to Eleanor's character. In short, changes across each iteration of Eleanor illustrate the lack of delineation and lightly sketched nature of the character. The court considers each asserted character in turn. This is great. This is like the dissecting the joke portion of the opinion. Let's dissect. Let's really dissect Eleanor. This is some sort of freshman essay about describe the character of, whatever. Describe the character of Scrooge McDuck. And the court, being good court, is going to elevate this assignment to new heights. Right? We're going to take this freshman essay, and we are going to heighten this and make it into a court decision. This is good shit. All right, so let us dissect the character of Eleanor and see if there's anything left after we're done. Physical appearance plays a role in the second prong inquiry, but alone is not decisive. The film consistently depicts car of Eleanor designation with physical characteristics of Ford Mustangs, and of course, attendant conceptual characteristics attending to that make and model. However, the film's inconsistent depictions of vehicles called Eleanors undercut any other aligning physical characteristics. First, the type of Ford Mustang described by the Eleanor codename changes between trilogy and remake. In the trilogy, Eleanors are 1973 Ford Mustang Fastbacks. They are modern vehicles common enough on the road that the heist teams in Gone in 60 Seconds and Deadline Auto Theft encounter multiple instances of such vehicles without actively searching for them. So yeah, in 1974, when this movie was made, the 1973 Ford Mustang was a more common car. The unexceptional nature of Eleanor in the trilogy is most apparent in Gone in 60 Seconds, where one of Pace's accomplices avoids suspicion of an owner of a Ford Mustang he attempted to steal by explaining he thought it was his car. The plausibility of that explanation relies on the premise that yellow Ford Mustangs are common enough to be mistaken for one another. In contrast, the Eleanors in the remake are 1967 Ford Mustang Shelby GT500s, which are classic, uncommon cars. One character in the remake remarks that this type of vehicle is one of the rarest on the list of vehicles to be stolen, and there's only one of such vehicle in the area. The contrasting makes, models, and years of the vehicle, classes described by Eleanor designations in the trilogy and remake not only diminish the physical similarities between depictions, but also weaken any conceptual connotations about the vehicles that might be shared between depictions, such as value, rarity, and style. I like it. In 1974, the 1973 Mustang was around a little bit. The idea that, you could just substitute one for another, no big deal. In 2000, the 1967 Shelby, a little bit rare, a little bit harder to come by. So it's a different year, a different make, a different model. I am loving character analysis done by court. Character analysis done by court is best character analysis. If I ever become a judge and I have to do character analysis in an opinion, my English teachers will be like, they will die because they didn't think I was very good at this. But I that's fine. I look forward to my character analysis not only being good but being definitive, because it's a judgment by a court. So that is the legally correct determination. At least as it applies to this case. That's good shit. Second, the physical characteristics and appearance of Eleanor's is not consistent among them within the films. In Gone in 60 Seconds, Deadline Auto Theft, and the remake, one instance of Eleanor appears first in pristine condition, and over the course of the film sustains increasing amount of damage. Other Eleanors have static physical appearances. 3 of the Eleanors in Gone in 60 Seconds and Deadline Auto Theft maintain an undamaged appearance, and the Eleanor in the diegetic scenes in Junkman maintains a damaged appearance with cleanly painted messages printed across the body. The other depictions of the Ford Mustang and the Junkman are as a toy in a diorama, an illustration on a poster. The physical appearance issue is most apparent in the remake. The vehicle gifted to the protagonist at the conclusion of the film is not immediately recognizable as an Eleanor by virtue of its physical characteristics as a Ford Mustang Shelby GT500. The Eleanor with the most screen time in the film is a sleek, shiny, fast car, whereas the Eleanor in the conclusion is rusty, decrepit, and slow. Had the vehicle not been identified as an Eleanor in spoken dialogue, a viewer might not recognize the vehicle as an Eleanor by physical appearance alone. Thus, Eleanor characteristic cannot be delineated on the basis of physical condition, old or new, damaged or undamaged. I love it. I love it so very, very much. This is great. Third, physical characteristic customizations or modifications to a Ford Mustang are not consistent or identifiable. The Haliki party submit that Eleanors in the trilogy are highly customized and feature a custom color that was not offered by Ford or Shelby. There's nothing particularly identifiable about the color of the vehicles portrayed. It reads as standard yellow color car, and within the context of the narrative of Gone in 60 Seconds and Deadline Auto Theft at least, it is implied to be a standard car color. Any customization to Eleanors in the trilogy are not readily identifiable in the works themselves. In any event, these characteristics are not shared with either of the Eleanors portrayed in the remake. The apparent modifications to the first Eleanor portrayed in the remake, such as the nitrous oxide switch with the button labeled Go Baby Go and unique inset lights, are in turn inconsistent with the identifiable modifications, if any, to Eleanors in the trilogy. No set of modifications or customizations is consistently portrayed in connection with the Eleanor vehicles. In short, they are only consistent and identifiable physical characteristics of automobiles designated Eleanor or make and model. Yeah. The strongest conceptual link common to the cars themselves, named Eleanor across the films, and within each film is the Eleanor designation itself. Not every Ford Mustang that appears on screen is called by the Eleanor designation, particularly in Junkman, in which Eleanor's name is not spoken, except in a single scene of dialogue between 2 ancillary characters. But in the vehicles in the other 3 films fitting the respective Eleanor depictions are almost uniformly referred to by Eleanor's name. Notwithstanding the use of Eleanor designations in these 3 films to classify vehicle phenotypes, as opposed to naming specific vehicles, undermines the delineation of the purported character. That is a very, very sophisticated way of phrasing that. I think the court might have had fun with this. I'm just thinking. I think the court might have had some fun with it. It's a very sophisticated way of saying, the cars aren't distinct enough. The court is cracking me up, man. I almost feel like the court is being like overly falutin in its language as a critique of the part of the of Haliki's position. I feel like maybe they're being overly verbose and overly descriptive as a rebuke, because maybe the language of the party was overly this same tone, and so they've adopted the same tone to rebuke it. I think the way it's written may be a critique in and of itself. I think the court might have had some fun. For example, in Gone in 60 Seconds and Deadline Auto Theft, each instance of Eleanor is fungible, as the only one must be stolen to be complete the order heist. The exonic code name in these film leads to the viewer to conclude that each new Ford Mustang that appears on screen in a sequence is a different vehicle from the others. In other words, because Eleanor is effectively synonymous with the 1973 Ford Mustang Fastback in these films, its value as a delineating characteristic of any given instance is diminished. This is good shit. Thank you very much, internet commentator, for that kind comment. This is fun. The conceptual characteristics consistent among depictions of Eleanor virtually end there. Eleanor is not particularly hard to steal. Rains was able to secure the first Eleanor in the remake, and Pace is able to get behind the driver's wheel of all 4 Eleanors depicted in Gone in 60 Seconds and Deadline Auto Theft within a matter of seconds. That is 60. Lol. To the extent these depictions of Eleanor are hard to keep stolen, Whether due to a police chase or insurance status or else, other depictions of Eleanor are not portrayed as particularly easy or hard to steal because they're not subject to pilfering at all. No depiction of Eleanor in the Junkman is the target of theft, and the second Eleanor in the remake was lawfully purchased. Good shit. Many of the other conceptual characteristics identified by the Haliki parties, how can you not think law is fun? Just as a purely aside thing. How can you not think law is fun? How can you not think this is just great shit? This is great shit. This is fun. This is great. I love this stuff very, very much. Law is the best. Law is best stuff. I love reading these things. This is my favorite thing to read. I have books, but I read so many opinions. I read so many legal opinions. I don't read a lot of books anymore, which is fine because I like reading the legal opinions. It's my favorite thing to read. Also, they're very cheap. So that's nice. And I think it's the best writing. This is great. J.K. Rowling and Haliki have nothing on this court. Many of the other conceptual characteristics identified by the Haliki parties, that Eleanor can outmaneuver police vehicles, execute death-defying jumps, and endure long chases applies only to instances of Eleanor in Gone in 60 Seconds, Deadline Auto Theft, and the remake that are involved in the film's chase sequence. Other vehicles designated as Eleanor in those films do not exhibit those characteristics, and the Eleanor in Junkman does not exhibit them at all. Other claimed conceptual characteristics apply to only the first instance of Eleanor depicted in the remake. Only that vehicle, or vehicle class, is described or portrayed as unicorn. Where's Rob? Where's Rob from Law Number? That's what we need. We need Rob. We need Rob here. With certain elusive beauty, mystique, and aura. Only that vehicle exhibits any remotely human conceptual characteristics, such as sensitivity and temperament. Now, to be fair, most cars can be described that way, particularly older cars. It can be described as having sensitivity and temperament. Only that vehicle is spoken to by the protagonist as if it were human, contrary to representations made by the Haliki parties. Only that vehicle breaks down and doesn't start, and even then, one would be hard-pressed to extrapolate from that single scene in which vehicle malfunctions the vehicle's proclivity to break down is a character trait. Cute. Thank you, Laura, for the nice hat emojis. They're always appreciated. Finally, the Haliki parties assign anthropomorphic characteristics to the character, such as strength, talent, endurance, and tendency to always save for a leading man. It's a car. It's not Kit. It's not Herbie. In this court's view, these characteristics are an invention of overzealous advocacy. Eleanor vehicles may have human names and feminine pronouns, but their anthropomorphic features begin and end there. Eleanor vehicles feature no more anthropomorphic traits than an ordinary automobile. The skillfulness and talents exhibited in the chase and action sequences of the film are more appropriately attributable to the human protagonists that drive Eleanor, not monomically to the vehicles themselves. Wow. This court had a shit ton of fun. In short, at most, the Eleanor character is consistent identifiable traits and attributes that make it recognizable or that of a Ford Mustang called by the name Eleanor. These characteristics hardly amount to a core set of traits rendering the character immediately recognizable. For example, anointing a 2023 Ford Mustang Mach-E with the name Eleanor would not make the vehicle immediately recognizable as an homage, let alone an iteration of the vehicles that appeared in Gone in 60 Seconds. The characteristics shared by the automobile depicted in the film are too lightly sketched to meet the silken prong of the test. This is great shit. Thank you, Secret McSquirrel, for being here as always. I hope you had just a beautiful Christmas, and I hope all of you had a beautiful Christmas. I hope you all just had a great time, and I wish you all a happy, happy New Year. It's great. Life is good. We're hoping for continuing growth of the channel and stuff like that. The channel growth seems to have temporarily plateaued at 120-ish, but that's okay. Right, we had a nice period of growth there for a while. We gained like 20,000 things after the whole depth thing. That was really, really nice period of growth. And it seems like we've stabled out, which, happens. It doesn't last forever. But that's cool. And we keep trying different things and new things to help the channel grow with thumbnails and making changes to the thumbnails and how they're presented and titles of things and stuff like that and selection of thumbnails, try to make things more interesting and continuing to look for people who can reliably edit for basically no money. That's tough, and other things. So we appreciate everyone who helps the channel, helps it grow. Tell your friends, remember to retweet this. That helps. All those things. And I would expect that we will get another growth spurt once we start covering another trial back to back. So probably the Courtney Clenny case or the Murdaugh case out of South Carolina or something like that. I suspect that we'll get some really good numbers and growth as a result of that. So we'll see. And if the court changes their mind about Dave Belvallo, I'd love to cover that one. Probably not, but In short, success will come. I'm feeling very successful now. I'm feeling like things are going great. I'm very happy. I did gain like 75,000 subscribers this year. That's a lot of success. So, that's good. That's a lot of success. This is still viable. It's not, it's still viable in terms of its channel. So I'm having a lot of fun. I'm having a lot of good time doing with you guys. I'm very grateful for what I have. And I hope that we'll get more. It's great. Okay, let's see. For example, okay, we read that. The characteristics shared by the automobiles depicted in the film are too lightly sketched. Okay. In the third prong of the test, courts consider whether the character is especially distinctive and contains some unique elements of expression. Characters do not meet this element if they are a stock character, like a magician in a standard magician garb, or a character that fits general stereotypical characteristics, like a loyal friend or old scholar. Yeah, you need a little bit more than scenes of fare. You need a little bit more than tropes. All right, that doesn't work. For the sake of argument, the court assumes the second prong is met on the basis of Eleanor's consistent identifiable characteristics. That is, the name, make, and model. Given these characteristics, the court examines whether Eleanor is especially distinctive. So we're going to assume that it's met for 2, even though it's totally not, so that we can properly analyze 3. The mere delineation of a character name is not sufficient to satisfy distinctiveness. The case at bar makes this principle obvious, as Eleanor's name is not especially distinctive or unique. In Gone in 60 Seconds, Deadline Auto Theft, and the remake, the heist teams use car codenames to avoid arousing suspicion. That is, within the narrative of the films, the thieves employ common feminine names because they're indistinct. That's a nice way to turn it on its head. The name Eleanor is used specifically because it's non-distinct. That's an interesting thing. Eleanor is a common spelling of a standard feminine name used frequently within the United States. Assigning a human name and gender pronouns to a car or other inanimate objects is not particularly unique, and certainly not enough to justify intellectual property protection. Yeah, for whatever reason, to the extent that the English, or at least the American language, I suppose, I don't know how it is in other English-speaking countries, so I'll say the American language. To the extent that the American language grants gender-based names to objects, they're female, right? So, cars and boats, it's always she. I'm not sure why, but that's how we roll. If you do it at all. Unlike the Batmobile, Eleanor is not uniquely and highly recognizable name that would evoke recognition as a character from Gone in 60 Seconds. It should be equally obvious that Eleanor's make and model do not make it especially distinctive. Even within the narrative of Gone in 60 Seconds, Deadline Auto Theft, and the remake, Ford Mustang cars fitting Eleanor's designation are not unique. The name describes a class of vehicles. In Gone in 60 Seconds and Deadline Auto Theft, Eleanor's are practically a dime a dozen. Lol. The Ford Mustang characteristics of Eleanor make it no more than a stock Ford Mustang. Maybe with some alternate paint, but that's not going to cut it. Maybe because it was painted yellow, and maybe the manufacturer didn't offer yellow. But I'm sorry. Taking a stock car and painting it yellow does not, in the court's view, or in my view, change it into a non-stock car. That's dumb. It's like putting a bumper sticker on your car makes it non-stock. I mean, come on, right? Considered together or alone, Eleanor's consistent and identifiable characteristics do not make the character distinctive enough for identity copyright protection. The third prong is therefore unmet. But Ford did offer it in yellow. Well, apparently not that particular shade of yellow. I guess from the description from the court, apparently, what's her name? Apparently Haliki argued that Ford didn't offer that particular shade of yellow. They didn't offer that particular shade of yellow. It was a different shade of yellow, not offered by Ford. I'll let you guys quibble on that one, but that apparently was an argument. Oh, they didn't offer that particular shade of yellow. This is a different shade of yellow, and that makes the difference. I should cover some of the hearings the Republicans will hold. Maybe I will. That could be fun. For these reasons, the Shelby party's motion for partial summary judgment on the issue of copyrightable is granted in substantial part, and Haliki's motion on the issue is denied. Eleanor is not subject to standalone copyright protection. On this basis, the court dismisses Haliki's party's 4th, 6th, 7th, and 9th counterclaims. Because Haliki is not subject to copyright, the Shelby party's motion for partial summary judgment on the issue of substantial similarity, which assumes that they're copyrightable, is moot. The court denies the motion. In the motion for partial summary judgment on the issue of copyrightability, the CR parties raise arguments that's separate from the Daniels test. Because the Daniels test is dispositive, it's denied as moot. Okay, so now that we've moved on from contract claims, so yeah, I'm not sure about the Daniels test. Like the court, I have my questions about the Daniels test. I'm not necessarily sure that I have anything better than the Daniels test, but you know, it is perhaps not all it could be. Oh yeah, hold on, my focus is wrong on my camera. Hold on 1 second. There we go. That's better. The f-stop was too high. Yeah, I think I want a little bit more. Hold on. That's better. That's a little better. Okay, great. Okay, let's see. Where was I? Let's go to the breach of contract claim. The Shelby parties claim that the Haliki parties breached their settlement agreement that ended the previous federal action. The settlement agreement is governed by California law. Under California law, a claim for breach of contract requires a party to show the existence of contract, performance or excuse for non-performance by the one party, the breach by the other party, and damages. So yeah, just basically your standard breach of contract action. Yeah, the power in my apartment went briefly out and it reset all the settings on the camera. So I hadn't noticed that particular setting had been reset. So, you know, I didn't want quite as much f-stop. I wanted a little less blurry. So. The Shelby parties claim that the Haliki parties breached the agreement by denying the Shelby's parties trademark, trade dress, and other rights in the GT500 vehicles by contending the Shelby parties, business parties, and licensees are not permitted to manufacture, market, or sell GT500 vehicles. Asserting claims against the Shelby parties' business partners and licensing for using the Shelby marks and trade dress of the GT500. There's problems with the Texas power grid. Oh yeah, I mean it went off for just a second, but it was enough to reset the camera settings. Some people lost power longer, so I'm grateful for what I had. Asserting claims against the Shelby party's customer, which claims have been released by defendants pursuant to the settlement agreement. The Haliki party has acknowledged that they have asserted claims against the GT500E customers, as well as the Shelby party's licensees who are manufacturing the GT500CR vehicles. Notwithstanding, the Haliki parties argue that the text of the settlement agreement does not preclude them from asserting or threatening to assert claims against non-parties concerning the GT500E vehicles that were subject to prior litigation. So one of the things they're saying is our settlement agreement, doesn't preclude us from threatening third parties. Our settlement's only between us. And so whatever rights we do or do not have does not actually preclude us from threatening other third parties. So we're open to the possibility that our threats are based on nothing. Okay. Citing Section 17, the Shelby parties contend that the Haliki parties released any claims against innocent past, present, and future owners and vendors of GT500Es, so their conduct violates the provision of that agreement. The court determines that as a matter of law, the settlement agreement is not reasonably susceptible to Shelby's party's interpretation of Section 17. Contract interpretation generally presents a question of law. It sure does. What does the contract mean? What does it cover? And then as to whether or not those elements are met, maybe a question of fact, but the actual interpretation of the contract is a question of law. Court applies a two-step approach when parties disagree about meaning. First, the court asks whether, as a matter of law, the contract terms are ambiguous. That is, the court considers extrinsic evidence to determine whether the contract is reasonably susceptible to a party's preferred interpretation. If the ambiguity persists, the court admits extrinsic or parole evidence to help interpret the contract. So if the contract's clear on its own terms, then fine. If not, we might look outside of it. In the first step, courts decide whether the language is reasonably susceptible to interpretation urged by the parties. If it's not, the analysis ends, right? The contract is clear on its face, then the contract governs. If the language is reasonably susceptible to more than one meaning, but there's no material conflict in the extrinsic evidence, a court may interpret the conflict as a matter of law, but the conflict is in the evidence. It must be resolved by the fact finder. So, the contract requires, for example, the delivery of $100,000 in exchange for car, right? So what $100,000 is and what car is for the court to determine. Whether or not those things happened in reality is for the finder of fact. So if you had a contract that said $100,000 in exchange for a car, and that's all it said, then what is the car? That's a question of law. Was that delivered is a question of fact. That's the distinction. Section 17 of the agreement pertains to Eleanor contracts from customers of Unique Motors and Unique Performances. By its own text, the provision applies only to contracts with specific existing customers. The provision does not release any claims. Instead, the preceding section requires the dismissal of pending litigation and release of any existing or past claims between Shelby and Haliki. The release does not contemplate non-party or future claims. As admitted in the Shelby party pleadings, the settlement agreement does not expressly address a release by defendants of any potential claims against customers of the Shelby parties or their licensees who had purchased vehicles. So the contract doesn't cover this. But then again, the court just determined that you have no copyright in it. So you can't make the claim now because you have no basis in fact or basis in law. So, you're not bound by the contract, but you're bound by the fact you can't have copyright in it, which is a legal determination. The Shelby parties offer no material, extrinsic evidence or cogent argument to support their position. The agreement makes clear that innocent owners of GT500Es or any non-party parties are innocent and not to be harassed. Section 17 contains no anti-harassment language. The Shelby parties assert that their interpretation is viable because the Haliki parties did not take action against 500E owners for a decade after the agreement, but the Haliki parties' inaction cannot generate a new obligation untethered to the text. So their behavior might be partially suggestive, but it can't generate a new obligation that isn't there. That's true. As a result, the claim for breach of contract must be dismissed. So not so much on the contract, but then again, you have no copyright, so stop. The Shelby parties assert that Haliki parties breached the implied covenant of good faith and fair dealing attaching to the settlement agreement by asserting claims against the Shelby parties, customers and licensees concerning the vehicles that allegedly infringe the leaky parties' intellectual property. California law implies a covenant of good faith and fair dealing in every contract to prevent a contracting party from depriving the other party of benefits of the contract. The scope of a contract prohibits by covenant of good faith is circumscribed by the purposes and express terms, but a violation of express provision is not required. A party violates a covenant if it subjectively lacks belief in validity of its act or conduct is objectively unreasonable. Here, there are tribal issues as to whether the leaky party's conduct towards the non-parties to the settlement agreement deprives the Shelby parties of benefits of the agreement and was objectively unreasonable. The settlement agreement, which arose from litigation over intellectual property interest in the GT500E, releases past and present claims between the parties. The leaky parties agree to transfer all intellectual property rights in the GT500 to the Shelby parties, and also the Shelby parties have trade dress rights in the Shelby GT500 and would continue to manufacture, market, sell, and or license them. The leaky parties agree not to initiate any lawsuit against Shelby or its business partners or licensees for licensing or use of trade dress of the GT500 and release and waive any such claims. Shelby's party counsel from the prior litigation testified that they were under the impression the agreement resolved the entire dispute as to intellectual property interest in the vehicles at issue in the prior litigation. Viewing evidence, I'm sorry to hear about your flood, man. That sucks, Crystal. I hope that that's resolved real soon. Viewing the evidence in the light most favorable to the Shelby parties, there is a genuine dispute as to whether the purpose and express terms of the settlement agreement, particularly its purpose to resolve the intellectual property dispute over the GT500Es, and express terms affirming the Shelby parties' intellectual property rights in the GT500, prohibit the Haliki parties from asserting claims against non-parties. The Shelby parties offer evidence and argument that could convince a jury. The Haliki parties' conduct lacked a viable legal foundation and thus was objectively unreasonable under their agreement. So there might be something there under the doctrine of good faith and fair dealing. So the express terms don't govern it, but you gave the GT500 to Shelby and all trade dress to Shelby, and then you're suing third parties based on the name because it's the character, even though Shelby has all the rights to the vehicle. So yeah. The leaky parties assert the Shelby parties cannot maintain their claim because implying an obligation not to make claims against GT500E customers will contravene the express terms. Not so. Although the contract releases claims against the Shelby parties, the leaky party and their business partners, the contract is signed as to release or maintenance of claims against GT500 owners. So they can bring a party, they might be able to bring a claim, and also all those owners might be able to bring a claim to the extent they're not barred by the statute of limitations or other things. Hey, Mask, thank you very much for the gift memberships. It is appreciated. Thank you very much. We always appreciate everyone who helps to support the channel financially, and I'm sure everyone appreciates the new gift memberships. That's very kind of you. In the second and fifth claims, the Haliki parties contend that the Shelby parties breached the settlement agreement and a side letter described in Section 12 of the settlement agreement. The settlement agreement and the side letter provide that the Shelby parties shall not use or license in any way, shape, or form any of the property rights described transferred to the Haliki parties, which expressly includes the right to copyright the Eleanor character from the remake, but is not copyrightable. The Shelby parties also agree not to sue the Haliki parties for licensing, using, manufacturing, or selling Eleanors from the original or remake, gone in 60 seconds, as embodied in photographs attached. Haliki parties assert that Shelby parties breached their formal obligations by licensing the GT500 CRs, and later obligation by initiating this lawsuit. Hey, how are you doing, Ali QOD? I'm glad you're here, and I'm glad you were able to make a live. That's very cool of you. The Shelby parties assert that the Haliki parties' contract claims hinge on a copyright inquiry. This is true in part, but not in toto, which means in total, but we have to be fancy about it. First, even when the court determination that there's no independent copyright in the Eleanor character, Shelby still agreed not to use or license in any way the intellectual property rights in the film remake itself. The intellectual property in the Shelby parties must refrain from using or licensing is broader in scope than the purported copyright in Eleanor. Second, the copyright question does not resolve the Haliki party's second theory of breach, which is predicated on the initiation of the lawsuit. Nevertheless, summary judgment in Haliki party's favor is inappropriate for three reasons. First is a tribal dispute as to whether the Haliki parties performed their obligation under the settlement agreement. And if they didn't, then they can't sue. Because you can't be in breach of contract and then also sue for breach of contract. That's not how that works. The Shelby parties offer evidence that the Haliki party's license converted a Shelby GT500 into Eleanor. Viewing the evidence in the light most favorable to Shelby parties, a reasonable fact finder could determine this conduct amounts to a material non-performance of the Haliki party's obligation not to allow entities they control to use a Shelby GT500 vehicle in the manufacturing or selling of Eleanor. That's fine. So, like, what can you sell? Maybe nothing. Maybe that's the point. If you can't use a GT500 in the making or selling of Eleanor's, what's left for Eleanor? Not much. Thank you very much, Mask316. That's very cute, and I appreciate the sentiment. Thank you. Normally, the question of whether there's a breach of obligation is a material breach so as to excuse parties' performance by non-parties is a question of fact. Second, the Haliki parties do not meet their burden at summary judgment as to the theory of breach of the Shelby party's obligation not to use Gone in 60 Seconds on Eleanor intellectual property. This theory relies on a wholly conclusory substantial similarity argument, insufficiently developed in the one paragraph of analysis the Haliki parties devoted to the moving brief. The Haliki party's assertion is particularly unavailing given the court's determination there's no independent copyright in Eleanor. In any event, the parties' proffer evidence given rise to a genuine dispute as to whether GT500 CR's design is substantially the same as vehicles previously produced by the CR parties under license from the Haliki parties, and therefore whether Shelby's party's licensing of those vehicles breached the settlement agreement. So there might be some sort of dispute as to who can make the Eleanors or not because of the nature of the settlement agreement, but Third, the Haliki parties do not meet their burden of production or persuasion as to their theory of breach of the Shelby parties' obligation to refrain from bringing suit. The Shelbys agreed not to sue Haliki parties for licensing, using, manufacturing, and selling Eleanors. Haliki parties failed to show the conduct for which parties sued Haliki, asserting the rights that Shelby parties expressly acknowledged belong to Haliki fits within any of the four limited categories for which the conduct agreed not to sue. That is, licensing, using, manufacturing, or selling Eleanor. Summary judgment of Haliki party's second, fifth counterclaims is inappropriate. So, yeah, not so much. So they can't sue over those specific things because there was a settlement, but this lawsuit goes beyond that. So it's not covered by the settlement agreement either. The Haliki parties rest their breach of contract claims against the CR parties on licensing agreement between two sets of parties for right to use intellectual property rights, trademarks, and copyrightable material relating to Gone in 60 Seconds and Eleanor, consistent with the star car character for Eleanor from each movie. The licensing agreement is governed by California law. In the motion, the Haliki parties assert that by manufacturing the GT500 CR vehicles substantially similar to the Eleanor car character replicas, which the CR parties have been building under the Eleanor license, CR parties breached their agreement to refrain from further use of the properties or any future reference to it, direct or indirect, in connection with manufacture, sale, distribution, or promotion of the products. For reasons similar to those discussed in the preceding section, the Haliki parties have not met their summary judgment burden on this claim. The argument they advance concerning the purported breach amounts to no more than bare conclusion that GT500 CR is substantially similar to vehicles the CR parties previously produced under license. Again, the court questions the merit of this argument given that Eleanor is not subject to copyright. At least there's a tribal issue of fact as to whether GT500 CR is substantially the same as the vehicles the CR parties built under the licensing agreement and whether the manufacturing of GT500 CR violates the agreement. Summary judgment is therefore inappropriate. Conclusion. The court grants the summary judgment for partial summary judgment on copyrightable and denies the hot-cut parties and motions on this issue, denies Shelby parties' motion for summary judgment. Eleanor is not subject to standalone copyright and a dismissal of a whole bunch of claims. And then there's an appendix. Here are the vehicle descriptions and their code names from Gone in 60 Seconds. Here is the unsuccessful attempt to steal the first Eleanor in Gone in 60 Seconds. What is this woman wearing? Lol. Here is a picture of Pace preparing to steal the second Eleanor in Gone in 60 Seconds. Here's a picture of Pace spotting the third Eleanor in the movie. Here's a picture of the third Eleanor's slow jump motion seen in Gone in 60 Seconds. Kick ass. Here is Pace at a police checkpoint with the fourth Eleanor in Gone in 60 Seconds. Here is the card featuring Eleanor in the Gone in 60 Seconds opening title sequence. Here's a clip from Gone in 60 Seconds showing through a screen in Junkman. Here is the diorama version of the damaged vehicle in the Junkman. Lol. Allison Larson says you love me, but? When do you love me, but, though? Aww. Here's a picture of two men arguing over Eleanor in the Junkman. Here's a photo of Hollis driving the vehicle through a wall to escape a gunman in the Junkman. Here is the obscured vehicle in the film premiere of Junkman. Here is Rains surveying Eleanor at the International Towers in the remake. Here is Rains flying through the sky with Eleanor over a traffic jam in the remake. Here is Rains' crew surprising him with another Eleanor in the remake. Thus, that brings us to the end of that case. So I thought that was very, very interesting. Very, very interesting. I pronounce Haliki wrong. Haliki. I'm doing my best. Haliki. There's some dispute in the chat over the proper way of pronouncing names. Also, you don't know their life. Maybe that's the way they pronounce their name. How do you know? Have you ever heard them pronounce their name? Yeah. I don't know. Also, me pronouncing names wrong is half the fun over here at Uncivil Law. So, all that stuff. So, yeah, I thought this was a very, very interesting case, a very, very interesting copyright analysis. So, yeah. So there might be some dispute as to who can make these cars as between the two of them. But all these people making kit cars are basically in the clear because there's no copyright. So, yeah. So your ability to own Eleanor is getting more and more better with every passing moment. And I'll give you a hot tip for the holidays for sure. This was a lot of fun. I hope you had a lot of fun with it. It's good, some good stuff. Well, and I hope that creator, and I'll have to tag him in the video description or title. Build is for B. I don't know if he's still around, but I'll tag his channel because it'll be relevant to his story and relevant to what's going on there. So all kinds of good stuff. So I hope you enjoyed this. Let me check the super chats before I sign off. I don't think there are many of them, but always nice to try to read them at the end. Let's see. Just the one today from Annabelle. Have a wonderful new year. And then there were a whole bunch of people who gave some new memberships and stuff that was really, really appreciated. So all that good stuff. Okay. I'm going to sign off for now. And I really hope you enjoyed all this. If you've been enjoying this legal education content, please remember to do all the YouTube things, like, comment, subscribe. If you hit that like thing, it really does help with the engagement. It helps with the recommending the thing. Please make sure that you're still subscribed. Maybe you thought you were subscribed. Maybe you were subscribed to the Star Stream. Maybe you become unsubscribed since then because YouTube or whatever. So make sure to double check. And did you know for a mere 99 cents, YouTube can become an uncivilian? It's true. For 99 cents, you help to become a member of the channel. You get to see some streams when I'm doing some batch records. The first part of batch records is free, and then you get to see some streams after that to see some stories and help with the creation of stuff. And you get some cool little scales of justice by your name, and you get some emojis, and you help support the channel. all that good stuff. It's all good. So make sure to do all those things. And I hope that you just have the very best day and wonderful, wonderful new year. Until then, my friends, I hope all's well. Cheers, my friends, and goodbye.